Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody. Happy New Year. First event for 2024. Today is our firm's January live virtual First Friday event, and I'd just like to wish everybody a Happy New Year. I see that we're having some people joining us here. We've got these numbers going up and up, 35, 38. It's going up by the minute. Just some starting points. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. I wish you and your association a healthy and happy, prosperous new year. Just in terms of my background, for some of you who may be joining us for the first time for First Friday, I've been representing HOAs and condominiums in the state of Arizona for the past 27 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. First Fridays are a great time to get your questions answered for free on Arizona HOA and condo law. Here's how First Fridays is going to work today. We already have a lot of questions, which is awesome. So thanks so much for being here today and participating. If you haven't already done so, please submit your First Friday question in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible, and I'll answer all questions between now and 10 a.m. Just a quick and friendly reminder, due to the large volume of questions that we receive, this free opportunity is limited to one question per association. So if you plan on submitting a question live today during this session, please include the name of your HOA or condo and your current role when you submit your question. We appreciate you understanding and following the rules for First Fridays. Okay, let's talk a little bit about our education plans for 2024. Maybe some of your goals for 2024 is to get a better understanding of how HOAs and condominiums work, or feel more comfortable with some problems that you're having in your association. So our free education opportunities for board members, homeowners, and managers is a great way to meet that goal. So just starting out, we're going to be continuing with our live First Fridays throughout 2024. So mark your calendars. It's going to be the first Friday of every month. We'll be here on Zoom and Facebook Live to answer your HOA and condo legal questions at no charge. So plan on us continuing this throughout 2024. In 2024, we also will be continuing our partnership with the different neighborhood services departments from around the Valley in Arizona. And these classes through the Neighborhood Services HOA Academy will be every third Tuesday of each month at 11 a.m. And so just mark it on your calendars. Our Neighborhood Services Virtual Academy is always the third Tuesday of every month at 11 a.m. And we're going to continue to address hot topics and headlines in the new year during our neighborhood services class. Anything that is on my radar as something that you need to know about as a board member, we're going to be talking about it either on First Fridays or on our Neighborhood Services Virtual HOA Academy. Speaking of that, our first class for 2024 for the Neighborhood Services Virtual HOA Academy is going to be on Tuesday, January 16th at 11 a.m. And we're going to be discussing hot topics and headlines for the new year. So check out our website on the upcoming seminars tab for more details on this class and other classes that we're going to be teaching. We also have a couple other classes that we're going to be teaching this year, individual classes for cities, a couple of them in person. So make sure you check out our website on those. I think we have one for Scottsdale and also one for Chandler in the first quarter of 2024. So I encourage you to go to our website and check out that information. Don't forget, too, that every time that we teach a class in Neighborhood Services Virtual HOA Academy, we are recording the classes. So you can find those classes either on Facebook Live or also on our firm's website at mulcahylawfirm.com. So if you can't tune in live, you can always go back and check out the classes later on your own time. Also, First Fridays are always recorded and they are kept on our Facebook page. I talked a little bit about goals. I've been working on my goals this week, too. For my firm, I'm also a board member, so I've been thinking about my board member goals for our association this year. and then my personal goals too. So I'd like to encourage you by sharing with you a 2024 goals worksheet. I really suggest that boards have at least 5 goals each year and a plan to implement those goals. Our firm has helped many associations develop, plan, and achieve goals over the past 27 years. The first step to getting there is working on this goals worksheet. Usually what happens is there's one driver person on your board, and that person is going to take the lead on creating the goals worksheet and then bring it to your board at your January board meeting and get input from your other board members and start talking about what are our top 5 goals for 2024. And we're going to be sharing this with you too. We created a special document for the goals that you can be using for your boards. Something to think about as the new year starts. It's a reset for your board. A common thing that I hear on boards, and honestly, I feel this way on my board. Sometimes I just feel crazy. We're trying to get a redoing of some common areas done. It's literally taken 3 years. It's driving me nuts, frankly. And one of the things that I wrote down on my goals for 2024 is, okay, we need a timeline. Like we need to hammer this down in a timeline and we need to get this done in 2024. And no more monkeying around with this. Let's get the funding in and let's get moving. A big complaint that I hear from board members often, and something that contributes to board member burnout, is we never get anything done. All we deal with are problems that are not urgent, but are important. So I really encourage you to take some time, work on the goals worksheet. Also check out our Eisenhower method cheat sheet about prioritizing goals for the association and coming up with different plans on how to get things done in your association. Also a really great resource. It tells you how to categorize problems as urgent and important and do those first. And then all these other ones you need to either do quickly, delegate, or push off to another year. Okay, let's talk a little bit about the Corporate Transparency Act. I know we have a question on this later, so I'm going to be talking a little bit more about it when we get to that question. But some of you may have received via email from the Arizona Corporation Commission on Tuesday of this week an email saying, hey, everybody, don't forget, the Corporate Transparency Act just went into effect on January 1st, 2024, and you will be required to comply with it by January 1st, 2025. I think one of the reasons why people tune in for these classes is because I'm real with people, and I'm going to tell you right now, this law is a nightmare, and I don't think it applies. Okay, so here's the bottom line. It applies to associations right now. But by January 1st, 2025, I think the legislature, and this is the federal government, is going to have a big wake-up call, hopefully, and they're going to carve out the associations, HOAs, and planned communities so that we don't have to comply with this law. The bottom line on this law is that the federal government is trying to crack down on terrorism activities in the United States. And as part of that, they're trying to have any corporations, LLCs, comply with reporting requirements to the federal government about who's in charge of the corporation, who are the board of directors, who makes the decisions. As part of this new law, the person in control, which for an association context is probably going to be the board president. You're going to have to provide your name, your personal information, meaning your personal mailing address, your driver's license number, your passport number. It's like over the top, right? How are we going to get people to serve on boards if they think that they're going to have to give all this information to the federal government? It's already hard enough as it is. The Community Associations Institute, which is a national think tank that helps associations, provides information to board members and homeowners and managers, they've put out a publication on it, which we're going to be sharing with you shortly. Their lobbyist is actively working to get the association carved out as an exception that this doesn't apply to. But it's a concern. I would be lying to you if I didn't say, okay, I'm worried about this because it's going to be a hassle. It's going to cost money for associations to comply with. And some board members are going to say, I don't want any part of this. And so we're keeping an eye on it. I'm hopeful. Let's put it like this. Somebody asked me a percentage. How hopeful are you that this is going to actually happen and will be carved out? I'm like 80%, 80%. I'm sure that this is going to be fixed in 2024 and we won't have to start reporting until at all. But if we are not carved out, this is going to kick in January 1st, 2025. We'll have a plan ready to share with you on how you can, comply with this if we have to comply as associations. Okay, we also have a link that we're going to be sharing with you shortly about our upcoming events, free opportunities for you to come to classes virtually or in person to learn more about associations. We're sharing that link with you. It's going to be also can be found if you're joining us later on our website at mulcahylawfirm.com. Obviously, we've got great participation. We have 73 people with us here on Zoom and additional others with us on Facebook Live. So hope you continue to join us for these classes throughout 2024. Also, one more plug, don't forget that we also have our cheat sheets, which is just a one-page summary of important topics. We have over 65 cheat sheets right now listed on our webpage. That's a great way to find an answer at 11 o'clock at night when you're upset about something on your association. Go to our videos on our website, go to our cheat sheets, and hopefully we can provide you some comfort and give you the answers that you're looking for. Okay, let's dive right into the questions. Today, the first question is, we are considering applying to the City of Phoenix for trash pickup, which will require a replat of our private streets, changing access from private refuse to public refuse. We have a surveyor, and apparently you're working on it. A dedication update also needs to be included in the replat per our CC&Rs. A dedication update must be approved by the membership. Our CC&Rs also state the HOA is responsible for trash removal. What kinds of things do we need to consider in this public to private trash process? Wow, really great question. I love teaching these classes because it's interesting to hear the different problems. And this is an interesting problem that I honestly haven't seen that often in my career. So first things first, going from public to private or from private to public trash is going to be a change for your community. And it might not be the same service level that you're used to. So I'm guessing what a driver is for this decision is financial considerations that you want to save money. So first things first, you need your homeowners buy-in on this. So you should be talking about this with your homeowners to make sure that everybody understands the benefits of it, financial benefits, and any other benefits. Maybe you get more trash pickup through the city. So that's the first thing. Make sure you've got buy-in from your homeowners. A great way to do that would be to do an informal poll. If you think you already have the buy-in from your homeowners, then you definitely need to hire legal counsel to help you with this process. You're going to need to do an amendment to your CC&Rs. You're going to need to do an amendment to your plat. And our firm would be happy to help you with this. This is not something that's going to happen overnight. This is probably going to be a mapped out process. It's going to take a couple of months to implement. So feel free to reach out to us. We're happy to help you with this. Okay, next question is from a board member. Can the number of rental units allowed in the association be restricted by the CC&Rs? And if not, are there current FHA requirements that should be followed concerning the number of rental units to maintain nonprofit status? Okay, a couple things. So yes, your association can pass rental restriction amendments, okay? It's kind of tricky because there's a case that was decided in 2022 called the Callaway case, which impacts amendments to CC&Rs right now. And so, and honestly, it kind of the same, analysis on the first question about amending the plat and the CC&Rs and the trash. This Callaway case is kind of scary, actually, because it says that associations can't amend their CC&Rs unless the amendments are foreseeable and reasonable. And what's foreseeable is, honestly, it's going to vary from judge to judge, as to whether it's foreseeable that this amendment could be made in your association. And I think Callaway is something that honestly could be fine-tuned by the Supreme Court or the Court of Appeals in 2024. Actually, I hope it is, because I think it's not correct law. It's too overreaching, and I think it misses the point on the fact that CC&Rs can be amended. That's why we have an amendment provision, and state law encourages amendments in many different instances. So back to your question. Can we implement rental restrictions on rental properties? Yes. Can we limit the number of rental units in an association? That's a little more tricky, because in theory, it sounds great. Like, okay, we're only going to allow 20% of our units or lots in our association to be rental properties. But then the practicality of it is how do we decide who's in that 20%? Are we going to have a lottery every year? And if you don't win it, what does that mean? Your property just sits vacant for the year? That's going to cause lawsuits, and people are going to be upset about it. And in my experience, it doesn't work. it creates a lot of legal problems for your association. So can it be done? Yes. Is it something that's smart to do? It depends. You really need to talk to our firm about this because maybe it works if you have a smaller association and you don't really have that many people that want to have a rental property in there right now, and putting a cap on it and saying this is the procedure to be allowed to be a rental, and then everybody who buys in knows that this is the situation, maybe it can work. It just depends. Where it doesn't work is where you have a lot of people wanting to rent and you have a cap and there's not enough numbers in the cap to allow for the demand of the people who want to rent. And that's usually when we start to see lawsuits on this. So can it be done? Yes. Is it practical and a good idea? Depends. But my initial feeling is it's probably not. There are a whole bunch of other things your association can do to put rental restrictions in place. We have a great cheat sheet on this, on how to amend your CC&Rs and implementing rental restrictions. We also have a cheat sheet on rental properties on our website that I encourage you to take a look at. The next question that you had there is, are there current FHA requirements regarding the number of rental units? So FHA requirements, in order to get a loan from the government, basically, and if you're trying to get government financing through FHA, Fannie Mae or Freddie Mac, when you're applying for the loan, they're going to ask for information about the association. And this, comes into play with the homeowner or maybe even a buyer, homeowner doing a refinance or a buyer buying for the first time in your community. The association will receive a questionnaire. And if we say that we have 60% of our lots are being rented, it's possible that the owner or the prospective buyer won't be able to get financing through Fannie Mae or Freddie Mac because we have so many rentals. They see that as something that they're not going to give financing to somebody to buy in your association. So it's something you need to keep track of. It's not an FHA requirement. That's the Fair Housing Act. This is going to be more of an issue with Fannie Mae and Freddie Mac are the ones that are giving out the loans. FHA deals with discrimination in associations, so that's a separate topic. Is there a magic number? It changes all the time, unfortunately, with these loans. So I don't have a specific number, but if you have more than 30% of your properties being rented right now in your community, it may be hard to get this federal financing for prospective buyers or owners. And it doesn't have anything to do with maintaining nonprofit status, just so you know. Nonprofit status is through the Corporation Commission in Arizona, and rental properties has nothing to do with that. Okay, next question from an owner. We recently hired a management company. The members would like to see the signed contract for the company that we've hired. Can we ask to see the signed contract in its entirety, showing charges, rates, and the length of the contract? Yes, this is just a question about what records can you see as an owner in the association. If you want the specific link to the law on this, I go to our cheat sheet, our top 10 cheat sheet. I think it's number 6, 5, or 6 or maybe it's number 10 now. I think we moved it to number 10. And that just talks about what you can request as an owner in terms of what association documents you're entitled to see. So here's the bottom line on this. Yes, you are allowed to see the management company contract. However, if your board chooses to redact the amounts, and by redact, I mean blacken out so you can't see them. If your board chooses to redact the amounts that are owed to the management company each month and the Exhibit A charges and the monthly fee, they have the right to do that. Now, as a legal counsel representing associations, I always tell my boards that I work with, please don't do this because it just causes unrest, confusion, and it looks like we're hiding something, and we're not, okay? Everybody is entitled to see how the money is spent in an association, and there is, no reason, in my opinion, why you shouldn't be sharing this information. Now, sometimes for self-managed associations, there maybe you don't want to share for these large master plan communities that have a lot of employees, maybe you don't want to share everybody's salary for privacy reasons, but there's no reason, in my opinion, to not share the management contract and how much you're paying, your management company, including the Exhibit A, because I think it just causes way more problems. It looks like you're not being transparent, etc. So they can do it, but is it a good idea? I don't think it is. Now, if you're in one of these associations where the management company or the association doesn't want to share how much you're paying the management company, There's a lot of other places you can find it. So you can go to the year-to-date budget and look at how much is being paid to the management company on the line item for the budget. You can request a copy of the check register. And on the check register, you can see what checks are being paid to the management company every month. So, it is ridiculous to not give this because there's so many different ways that you can find it if you're savvy as a homeowner. Okay, question number 4 from an owner. Our HOA held a meeting after the annual meeting, and the second meeting did not have an agenda. Residents had no idea what they would discuss, therefore there were few in attendance. Are the actions the board took legal? So I do get this question actually kind of a lot, and I just attended an annual meeting a couple weeks ago where this exact question came up. Typically what happens is your association has, their annual meeting, and you're required under Arizona law to have an annual meeting every year. And at the annual meeting, new directors are elected to the board. And as part of, at the annual meeting, sometimes your documents will say immediately following the annual meeting, the new board should meet to elect directors, or to elect officers, not directors. The directors are elected at the annual meeting, and then immediately after, the board has a short meeting to elect officers. So president, vice president, secretary, treasurer. And the big question is, if that second meeting isn't noticed by giving 48 hours notice to the membership, is it a valid meeting? I don't know. In your association, did your board do that? I guess, if I had to guess, I'd say probably no. And so if they had a meeting right after the annual meeting, what I would recommend is that they just reaffirm whatever was decided at that meeting at the next board meeting, next open board meeting that's properly noticed. If you want to do it perfectly properly in the future, when you send out your annual meeting notice, make sure you put on the agenda that's sent to everybody that at the end of the annual meeting, we're going to have a brief board meeting to elect officers for the association. And that way you'll do it right for next year. Okay, are the actions the board took legal? Probably. Is it going to be challenged? Probably not. The way to fix it is just reaffirm the decision at the next open board meeting. Okay, next question, number 5 from a board member. When should annual meeting minutes be approved? A lot of great questions on annual meetings today. So by members at the next annual meeting or by board members at the next open board meeting? So we have a great cheat sheet on this topic on annual meetings, which I encourage you to look at, and we're going to be sharing with you today as part of this presentation. Okay, so from a technical legal standpoint, the annual meeting happens once a year, and you approve the annual meeting minutes from 2023 at the 2024 annual meeting. So I know that sounds really weird to wait a whole year to approve the meeting minutes, but it's the members approve the annual meeting minutes, not the board. So you'll notice if you look carefully at your agenda for your annual meeting, usually the first thing we do after we establish a quorum for the meeting is that we approve last year's annual meeting minutes. And it's a vote that's taken, it's usually on the ballot for the election of directors. And we also will be voting on it at the annual meeting for anybody who turns in a ballot in person at the annual meeting. So it shouldn't be something that's approved by the board at the next board meeting. Now, that being said, what I really don't like to see is waiting a year to do the minutes because we forget what happens, right? On minutes, you want to do them right away while they're fresh in your head. So I can see what maybe is happening in your association is that the minutes are prepared after the annual meeting, and then the board receives a draft of them, and maybe they peruse them at the next board meeting. And maybe they approve that, yes, this is the content of what happened at the annual meeting, but that's not approving the actual minutes. They're just approving a draft. The actual approval will take place at the next year's annual meeting by the membership. Okay, next question, which is number 6 from a board member. We have a lot of board members here today, which is great. Does the Arizona Public Records Disclosure Act or the Arizona Condominium Act permit an HOA member the right to examine the ballot of every community member to see how and for what each HOA member voted in a community-wide vote for like board elections or a special assessment? So again, another question on what records can an owner see. So under the law in Arizona, a member can request, and the association must provide copies of any ballots that you have on record for any vote that's taken in your community. So yes, the only exception to this would be if it's like a secret ballot, like you have an association with secret ballot requirement, meaning that there's no identifier on the ballot, no unit number, no address, no name. You just give them the ballots, but they're kind of empty other than the vote, so they wouldn't know how the person voted. Short answer would be yes, they are entitled to see the ballots. Now, remember, some ballots we have to keep for a certain period of time. Like if you have a removal meeting of your board, you have to keep those records for at least a year, those ballots. Other ballots, most associations will keep for 6 years in case we're sued. Honestly, every ballot, I think, should be kept with the association's records for at least 6 years because there's a 6-year statute of limitations to sue for breach of contract. So it's fair game. Bottom line is it's fair game. And those owners can request to see it and we have to provide it. Okay, number 7, is it legal for an association to enter a property without the owner's permission? Our CC&Rs include a right of entry clause stating if an owner fails to maintain the lot and the improvements thereon in a manner satisfactory to the board with its agents has the right to enter the lot and repair the lot and the exterior of any improvements that may be necessary, provided written notice has been given and the owner has been given 15 days to comply. So this is a pretty common provision. It's called a self-help provision in our industry. And it is a legal provision. If it's in your documents, the board does have the right to comply with whatever it says the requirements are to enter your property. They have to give notice, but it's part of the contract. If the CC&Rs give the association the right to self-help and enter the association's property after giving notice, is that legal? Yes. It's part of the contract and you agreed to it when you as an owner bought in the association. One thing to remember on that, just be careful if you're a board using self-help, you want to make sure they got the notice. And if it's a dangerous owner, you want to make sure that you have a security guard there or somebody that is, going to keep everything peaceful. Okay, next question, number 8, from a board member. As a board member, whom do I owe the fiduciary duty to? Oh, I love this question. This is a great question. So important. The board or the homeowners? When questionable financial transactions are found and the president treasurer refuse to address the problem, what is the next step? Great question. So as a board member, you owe a fiduciary duty to the corporate entity, the association. Okay, you don't owe it specifically to the board. You don't owe it specifically to the homeowners. You owe it to the corporation. And your fiduciary duty requires you to have a duty of care, meaning that you make good decisions for your association. You investigate things. You look into things when you think that there might be some questionable financial transactions and get some advice on it. You have a duty of confidentiality as part of your duty of care, or your fiduciary duty, and a duty to not financially profit as a board member from your time serving on the board. Your fiduciary duty is owed to the corporate entity, the association. So you have to be making decisions that are in the best interest of the corporation. So you feel that there are some questionable financial transactions and you don't quite know how to handle it. What I would recommend you do is, number 1, go to your board and raise these issues at a board meeting, and also put it in writing and ask to have it kept with the association's records. I have these questions about the finances, and don't do it in a way that makes, everybody think that, you think they're stealing or fraud or whatever. Just in a genuine way, I have questions and I would like answers. Now, if they're shutting you down and saying, I'm not giving you this, you're not entitled to this or whatever, that honestly should be kind of a red flag to you that, like, hey, that's weird. That shouldn't be happening. We're a team here. We're all on the board. The management company should be answering questions. Now, that being said, I was the president of my association for the longest year of my life, and probably the most unhappy year of my life too, by the way. There was actually somebody on my board who was so difficult to work with. And I can assure you there were no irregularities on the finances in our association, but this particular board member had some issues and didn't understand how to read a financial statement. And I spent countless hours explaining how a financial statement works, how the year-to-date budget works. And this board member just continued to think that there was something funny going on. And so sometimes you get in that situation and it's frustrating for a board. So I get that side too. So everybody needs to be reasonable. A good way to handle it, if you are at an impasse on whether or not you think there's something funny going on in the financials, bring in your CPA, bring in your attorney, and ask for their opinion. That's a good way to break up the fight, or to, if you can't agree on something, get an independent, make sure they're independent person to come in and evaluate the situation. And that's a good way for everybody to get a higher comfort level. Next question, number 9, from a board member. Since we have 3 board positions open for our upcoming annual meeting and we're not getting any new interest, can an owner be appointed to the board if we can't get enough owners to run for the board, even if they have served their term limit, or do we go shorthanded? Okay, you have 3 board positions open. I'm assuming you probably have like a 5-member board or a 7-member board, and no one's applying. So you have your annual meeting, and you got to decide first, are we going to allow write-in candidates on the ballot? There should be a whole process on annual meetings. We already shared with you our cheat sheet on annual meetings. Please take a look at that because it talks a little bit about the pre-annual meeting process. But okay, so let's go back. So what do we do? We're having our annual meeting, 3 spots open, no one's running. No one offers to run after we ask repeatedly, is anyone willing to run? We have the annual meeting, we have an opportunity for write-in candidates. Nobody volunteers to be a write-in candidate for the board. So now we're sitting as a board and we have 3 open spots. Can we appoint people to serve on the board? 99% of the time in your bylaws, the board has the right to do this. And even if there's only 2 remaining board members, which maybe is less than a quorum if you're supposed to have a 5-person board, usually in the bylaws, it gives, even if you have 1 board member left, the right to appoint a new board, a new board meeting for the open spot. So yes, assuming your bylaws allow this, you can appoint owners if you find people after the annual meeting to serve on the board. What about people who are term limited? Can we appoint them? That's kind of a sticky wicket. What I would recommend is just amend your bylaws to get rid of the term limit. That's the safest way to do it. Hopefully you don't need a vote of the membership to do that, because you might not get the yes votes because people just don't vote if they're not even willing to run for the board. What you could do is reappoint the person who has a term limit. Maybe you could say something along the lines of, if anybody else is interested, the term limited person will step down. But in the meantime, amend the bylaws to get rid of those term limits. Next question is question number 10 from one of my favorite community managers. Great to see you here today. If a quorum is not met at an annual meeting and a subsequent meeting with a reduced quorum must be held after the annual meeting, unless the document specified otherwise, can an association call both meetings in the same day at different times on the same notice? For instance, can an association properly notice the first annual meeting on January 10th at 9 a.m. for the 50% quorum, and then also properly notice the second annual meeting on January 10th at 9:05 a.m. for the 25% quorum in the same notice? I like how you're thinking here. I have seen this before for associations. So, the provision in the documents kind of doesn't make sense, right? If they should just make it a 25% quorum. But assuming that there is no time limit or new notice limit, because sometimes in these provisions in the CC&Rs, what it'll say is, here's your notice requirements for, a special meeting to levy a special assessment. You have to give a certain amount of notice. And then after you don't get the quorum, it says something like, without any notice, within the next 30 days, you can have the second meeting. So maybe if the language jives with what you're trying to do here in your CC&Rs, you can do this. What you really might want to think about doing is just lowering your quorum requirement, because it sounds like this is something that is happening frequently, and it just makes sense. It's confusing probably to the owners. Why are there 2 meetings? Why is there 2 quorums? So you have to look at your documents to see whether you can do this. But based upon what you're telling me, it sounds like you can. Okay, question number 11. Our HOA bylaws are dated and confusing. Is there a model set of bylaws our board can review as we consider how to best update them? So again, look at our cheat sheet on amending associations documents. Great resource for you as you navigate your way through the process of amending your bylaws and your other documents. If you are working with our firm for the amendment to your bylaws, we can provide you with 3 different sets of bylaws that we think are good, that could be a good starting point for your association as you come up with the changes to your bylaws. Just piece of advice I'm going to give you is that bylaws are such a simple document for an attorney, or at least for me as an attorney with 27 years experience, to amend, that I'm not even sure you really need a model set of bylaws. Basically, if you just give the bylaws to our firm or to a firm that has a lot of experience in representing associations, we can crank through amending those in like no time flat. I mean, the bylaws are really simple to amend. If you're wanting to add a bunch of things as a board to the bylaws, you need to get some advice from your attorney, because the bylaws really are the how to run the board, how to run like the corporate formalities of your association. And it shouldn't include like use restrictions and a bunch of other stuff. That all needs to go in the CC&Rs. And if you're trying to amend the bylaws because it's easier than amending the CC&Rs, you're putting stuff in the bylaws that you legally can't do. So it sounds like maybe you need a little legal advice as a starting point. We offer a free 15-minute review. For some of you may have heard me talk about this before. If your association is interested in amending any of your documents, if you email me at bmulcahy@mulcahylawfirm.com and ask for the free 15-minute review, what we'll do is we'll look at the document. We'll tell you what the amendment provision is. We'll give you some very quick suggestions on what we think needs to be amended, and we'll give you a bid for how much we think it's going to cost, or an estimate as to how much we think it's going to cost to amend your documents. So you may want to consider doing that for your association. And this offer is open to anybody who's listening in on this Zoom and Facebook Live today. And we're up to 83 people on Facebook, on Zoom, and more on Facebook Live this morning. So that's awesome turnout. Okay, next question, number 12. The HOA board has not made important repairs as requested. Our landscaping water system is not working properly. Another issue is water damage from the HOA's broken pipe flooded our condo. We requested an answer from them in regards to the repair, as the pipe belongs to the HOA. I feel the management company works for the board and not for the owners. What should we do? Well, yes, these are all problems. You know, if your association isn't maintaining things that they're supposed to be maintaining, and you've got a pipe break in your unit, these are serious problems. You need to get some advice from an attorney, I think. First of all, are they required to do this? I mean, it sounds to me like the landscaping water system not working properly. I mean, that can kind of cut both ways, because are they working on it? Is the system antiquated and, they've been band-aiding it for 20 years and, the band-aids aren't working and they're coming up with something to fix it, and they're working on it? Then maybe you're going to have to just fall back a little bit, give them a little time to work on it. Or are they just totally blowing you off, saying, yeah, like, we're not doing that, we don't have the money, we're just going to turn it off, type of thing? Then you may have a legal claim. With regard to the pipe breaking, one good thing is there's a new law in Arizona that went into effect at the end of October that talks about insurance and in condominiums, and you have a right as an owner to make a claim on the association's insurance policy. You first have to go through the process of notifying the board that you want to make a claim for this. You definitely should keep that in mind as something you may want to be doing. You can look at our cheat sheet on this, on the new legislation, to find out more about this on our website at Mulcahy Law Firm. Another thing that you can do on these issues is hire an attorney to send a letter to the board about these problems. You can go to the ADRE, the Arizona Department of Real Estate, file a complaint against the association, and have an administrative law judge have a hearing on these issues and make a decision as to whether the board is acting properly. You can file a lawsuit. These are all different things that you can do as a homeowner to address these issues. Okay, next question from one of my all-time favorite board members. And it's kind of interesting. This person used to be on the board for many years and is now a homeowner, and she still comes, which is great to have you here every time. Our association now has a website. On this website, they post our documents, a monthly calendar with any events on it to include the date and time of that month's board meeting. Posted usually 3+ weeks before the meeting. Also posted is the month's board minutes that has always followed, that is the following month's board meeting. Again, 3 weeks prior to that meeting. Since we have no way of knowing how many residents use the website, Do these two notifications satisfy the Arizona open meeting laws with 48 hours notice of the next meeting? So I would say yes, it does. So I would check out our Arizona open meeting law cheat sheet. But basically the bottom line on notice for open meetings is board has to give notice 48 hours in advance of the meeting by conspicuous posting at the property or any other reasonable means. And that could be by sending an email to everybody, by putting it on a website. All of these different things would comply with the open meeting law, even if you just did one of them, which your board is doing. Okay, question number 14. I am an outgoing board member after 3 years. I just want to say thanks for all that you've done helping the Arizona HOA community. Please spend a brief moment talking about why you guys do all this work and or why the audience should continue to do all their work. Thank you for helping. What a nice question. And honestly, just so everybody knows, I do not pre-read these questions. I come in here at game time and I read these questions for the first time. So that can be good and that can be bad. But this question is a really good one. So you want to thank you for recognizing how much work we put into these classes. It's a ton of work, but it's a labor of love. I want to give a special shout out to my team at Mulcahy Law Firm. Everybody on my team helps prepare for these classes and help prepare for all the free information that we provide to our clients that we represent, HOAs and condominiums, board members, managers, and even to owners as part of these free classes. So especially to Morgan, who is on my team. I couldn't do it without her because she just tees it all up for me and makes it easy. So appreciate her very much. Okay, so why do we do these classes? I have been practicing law in this area since 1996, 27 years. I absolutely love this practice area. I am so fortunate that I somehow fell into this because it's just a perfect fit for me. I love working with the boards. I love solving problems. I love trying to turn around homeowners who are upset. I love working with the management companies that are helping the boards too. I am a total wonk on this. I read articles on the weekends. This is my life, right? I mean, I don't consider this a job. I love what I do. And one of the things that I noticed in 27 years of doing this is that there is a huge gap in information for board members, homeowners, managers, cities, towns, municipalities. And somebody needed to step in and start teaching these classes for free. And that's what I did. And I have kind of a funny story. I probably shouldn't divert too much, but I think it's important that you hear this. So I started my firm when I was 26 years old. I'm now 53. And when I was 26, I was so young, nobody was going to hire me, right? I'm laughing about it even now. I probably didn't even really know what I was doing when I was 26, but I was hungry. And I learned everything I could possibly learn about associations in, the first year that I started my law firm. And I started a newsletter that I called Community Association Legal Update. This was an old school newsletter. It was paper. And I went to the Corporation Commission and got 10,000 names of associations. And I created labels myself. And I stuffed every one of those 10,000 newsletters. I sent it out quarterly. I had to touch each one 11 times before I could put it in the mail. And so I used to spend my weekends doing that when I was so young. And it just kind of has evolved over time, right? So I guess the most important thing I would say is I'm committed to providing education to board members, owners, and managers because I care about our industry. I want you to be successful. I don't want you to have serious legal problems. I want to help you navigate your time on the board so it's not an unhappy time, so that you get things done and you can feel good about your community. And it's just changed over time. It started with the newsletter that I did, and then it evolved into teaching classes. I was the first attorney that ever had a seminar for associations. I had it at the Hilton on Central Avenue. Honestly, I couldn't even afford it. We had very limited food offerings, let's put it like that. And we had maybe 30 people come. And then over time, I've had classes where we've had 200 people there. And then over time, we didn't do as many in-person classes because we realized that these virtual classes in the pandemic were really taking off, and we had a lot of people that would attend, and people preferred to attend it, and people preferred having the recording after the fact. So we evolved into doing more virtual classes because we could reach more people. That's what we're all about. That's why I do this. I do it because I love our industry. I want to give free information. My mom was a teacher, so I think I kind of have a little bit of teacher in me, and I enjoy teaching the classes, and I learn from you. Every time I teach one of these classes, I've got my finger closer to the pulse of what's going on in our industry because I'm hearing the questions that are coming in, and I like helping people. That's why I became a lawyer. So that's why we do it, why we do all this work, and then why the audience should continue. Okay, please come to these classes because there's so many new things happening in our industry when you're on the board that you need to know about. The 5 new laws that just went into effect in Arizona on October 30th. There's important information in there for your boards. And so we put out a cheat sheet on it. We talked about the new legislation in multiple virtual classes. And I even talked about one of the things today. The Corporate Transparency Act is something you need to have on your radar because potentially January 1st, 2025, you're going to have some reporting requirements to the federal government on that. And also just having a sounding board where you can ask a question for free and give you some peace is just a really nice thing. One other thing that I want to mention, I hope I don't offend any management companies, but sometimes the management companies don't want their boards to have too much knowledge. And so they try to, they want to handle everything. Well, you're the one that has the fiduciary responsibility. You're the one that's going to get sued. And so you should have a place to go to get free information and a place to go to get the right answers and a place to go to question something that the management company is saying to you that you might not totally think is accurate. It's important for you to have information. That's why we teach the classes. And I hope you continue to come and encourage your boards to come. And the great thing about these classes being recorded is that you can get a clip of what I say and just send it to your board, or just tell them, go to minute 22 of this video and listen from minute 22 to minute 25. And she answered the question that has been bothering our board for 3 years. That's why I do it. Okay, for the outgoing board member, I wish you the best of luck. Thank you for your service to your community. And who knows, maybe you'll be back again as a board member. Okay, next question, number 15. Can an association board hold a closed executive meeting for the specific purpose of training new board members? Duties, responsibilities, functions of their office? Yes, you can. The best way to do this is to, have a boot camp and bring in an attorney to help teach this to them. We do this very frequently. We offer a boot camp for boards where I will, either myself or another member of my law firm's legal team will create an agenda. And it's like an power hour. And we go through all the different things: fiduciary duty, responsibilities of the board, keeping things confidential, what are our current legal problems, what are our goals for this year, etc. So the way to get it into executive session is to have your attorney there. It's the bottom line. And have a carefully planned power hour just to get everybody up to speed. If you can't have your attorney there, it's going to need to be an open meeting, and you'll have to give 48 hours notice to the membership. Okay, next question, number 16. A board member elected by the membership is continually in arrears with the payment of monthly fees. Without naming names, can the membership pass a motion at the annual meeting to charge a penalty when a member is in arrears? And can the motion state that a member in arrears cannot serve as a board member or can be removed from the board when in arrears? Are there time limits both before and after an appeal to the board? Okay, I think that's a little bit different question. Okay, so bottom line here, board member not paying their dues. That's a bad sign. Okay, as a board, hopefully it's not the president. The president should go to that board member and say, listen, it looks bad. You're a board member. You should be paying your dues. What's going on? Try to shame that person, honestly, into paying. If that doesn't work, you passing a motion at the annual meeting isn't the way to do it. what you want to do is you can already charge a late fee under Arizona law. So you're a condominium, you put in your notice here. So under the Condominium Act, you can charge a late fee anytime an owner pays an assessment not on time. So you got to look at what your documents say. When is it past due? In a condominium, there's no limit on how much you can charge for a late fee unless your documents put a limit. I would recommend to follow the Planned Communities Act for a late fee charge. So charge it on the 16th day of the month, and it's either $15 or 10% of the assessment, whichever is greater. But if your documents in a condo call for a different time period for it to be late and a different amount for it being late, you got to follow that. Doesn't sound like your documents have that though. So you don't need to do anything to charge that late fee, right? State law allows you to charge it. Second issue, can we just pass a motion at the annual meeting saying, hey, you can't be on the board if you're in arrears, or you're automatically resigned from the board, or you're removed from the board? So you can't do that by motion. I mean, it's not effective. It's not going to make that legal. The way to do that is to put it in your bylaws. And our firm can help you write something like that if your association wants to do an amendment to your bylaws to vote on that. And honestly, that's kind of an easy vote to pass because people see that and they're thinking to themselves, yeah, the board member should be paying assessments. I mean, they're enforcing payment of assessments against other owners. It's improper for them not to be paying assessments and a possible breach of their fiduciary duties to the corporation. Okay, next question, number 17. We have been given some info on the Corporate Transparency Act and the need to register. How are HOAs supposed to comply? And does the personal info on the specific board member need to be included when doing so if we have a contracted management company? So great question. A couple things on the Corporate Transparency Act. Okay, it's federal law. It is in place right now. It started January 1st, 2024. The reporting requirements don't start until January 1st, 2025. Like I said at the beginning of this presentation, I am 80% sure that the federal government is going to wake up on this and realize that HOAs and condos are not the type of entities that they are targeting to report on this. No terrorist activities in HOAs and condos. And this is a huge burden financially for associations because who's going to do this? Either the management company is going to charge you to do this or law firms are going to charge you to do this. And every time the board changes, board member resigns, new board at the annual meeting, you're going to have to update that information. And so it's a hassle and it's expensive. And this is a cost that is going to be passed on to the owners in increased assessments. So can we have, if this does eventually still apply to associations in 2025, can the management company just give their personal information? Well, no, because they're not a board member. The law is very clear. It has to be a board member. And I don't think it's a good idea. I think the question is kind of worded, or the law is kind of worded that the person in control. I mean, the management company is an employee or independent contractor of your association. They're not in control. The board is in control of the association. So the board has to be listed on this, in my opinion. Now, if the management company chooses to put their name there, I mean, is anyone going to question it? Probably not from the federal government. It's, this is a box checker, so to speak. And it's just something they're going to put in their files in case there is a problem so they can go back and trace it to somebody. Is it potentially a problem if the management company does it? Probably not, but it's probably not the right way to do it. Okay, next question, 18. Is the ARC, so Architectural Committee, in an HOA required to provide copies or information on building plans to an adjacent neighbor to the property being built on? Only if you require you to do that. It could be policies of your architectural committee. Architectural guidelines may set that up. Are you required to provide building plans to the neighbor? No, not unless somewhere in your documents or in your policies or in the board's directives or the architectural committee's directives saying that has to be done. Does it have to be done? Next question, number 19. At our annual or regular meeting, can we require the attendees be required to show video so you can verify it is the homeowner? I'm kind of laughing about this because sometimes I attend my meeting virtually for my association, and occasionally it'll conflict with like a sporting event for one of my kids. So I have the video off, but I'm 100% present, but I also don't want to not be there for my kids at the meetings at night. I don't want to miss both things. Okay, so can you require? I suppose you can. Is that going to make people upset? Probably, because sometimes people, are in their pajamas, right? Let's be real here, and watching the meeting and they don't want the camera on. What I would require, I think would be a good idea, would be make sure that they're using their name in the Zoom. If they're not using their name, like maybe they don't know how to do it, send them a message in the chat and say, unless you, respond back with what your name is, so we can verify that you're a homeowner. Unfortunately, we're going to have you exit the meeting. That's probably the better policy. Next question, number 20. Can you share the Arizona statute sections which deal with the concept of waiver and latches? So there really isn't an Arizona statute that talks about this. Waiver and latches it's a legal doctrine under common law, which means case law, that talks about if an association, or I'm going to use the example, if an association fails to enforce something in their CC&Rs for a certain period of time, and then we try to enforce it, a defense of an owner would be, well, I've been doing this. I've had this permanent structure shed in my yard for 18 years. You've waived your right to enforce it. So there is no statutory law on this. There's case law that supports this provision. What I recommend you do is just Google waiver and latches cases. Waiver is probably going to come up more than latches. Arizona case law waiver. See what comes up. There's many cases. There's not just one case that talk about this particular issue. Okay, next question, 21. Our HOA is now charging rental fees when reserving HOA facilities and also requiring homeowners to purchase a $1 million insurance liability policy. Wouldn't the association liability insurance policy be coverage enough? Is this legal or reasonable? Okay, so I see that you're running for the board. Let's see. We charge rental fees for reserving the HOA facilities. That's actually pretty common, honestly. If you have amenities in your association, where I live, we have a clubhouse. So if you want to rent it, there's a charge to do it, and you have to provide insurance. Insurance for the use of that common element for that day. So how it usually works for most associations is the association just provides a copy, the owner just provides a copy of their insurance policy and asks their agent to list the association as an additional insured for that event for that day. Or you can obtain a separate policy. It's usually a couple $100 to just get a policy for having the event that day in the common area facility. So is this something that we see? Yes. Is this a good idea? Yes. Okay, next question, number 22. Our HOA requires a buyer to provide their warranty deed. Is this a requirement of Arizona law or just good practice? I think it's fine that you request this. You can also find this online on the recorder's office, although the recorder's office is always about 2 weeks behind. Typically, how this can be handled is when the property is sold and it goes through escrow, you ask the title company when the property closes to just give you a copy of the deed so you have it. Where this can come into, if the title company doesn't do that, then you certainly can ask the owner for it, or you can get it online through the Maricopa County Recorder's Office. Where this comes into play is sometimes where there's like a quitclaim deed and it doesn't go through a title company and we have no notice that the property is transferred hands. So you definitely can ask for a copy of that. You can also find a copy of that on the Recorder's Office in Maricopa County or whatever county you're in. Question 23. We are having issues with our property management team. Continual rotation of managers. We all gave them a bad review. The director spoke to each of us, asked to help. Our president gave 3 top priorities. We never heard again. When asked, we were told to have sent the issues in an email. How do we go above the director, and should everything be in writing? Okay, so you're having issues with your management company. I know we have videos in the past. Go to our website and look at our video. Go to my website, mulcahylawfirm.com. Look at one of our videos on dealing with management company issues and how to work effectively with your management company. I mean, honestly, this is like a perfect example of a management company that's not operating properly, right? They have a lot of rotation of managers. That's a bad sign. You want to get one manager and you want to keep them, because every time you get a new manager, you lose 3 months because you got to get them up to speed. and with what the issues are and get them trained. And if they're just constantly rotating and you're having 4 new managers a year, what does that mean? You're getting nothing done. It sounds like you told them, hey, you're not doing a good job in your review. Then the director, who apparently seems to be a little higher up in the food chain, came, asked to help. I want to make this right, but then didn't make it right. You gave them 3 priorities. They haven't done anything. They haven't responded. I mean, honestly, the writing's on the wall. You need to get rid of this management company. Sorry to say, but it sounds to me like there's problems that aren't going to be fixed. Of course, you can go up the food chain higher, go above the director and try to talk to the president of the company. But I mean, I think what you're seeing is like upper management is not understanding that you're not happy and doesn't care enough to answer. That's a problem. Like anything, there's problems always in everything in life, right? So if you have a problem and you escalate it to the person who's in charge and they're not doing anything either, there's a problem in the company. So move on. Reach out to our firm. We have a sample RFP, request for proposal, that we can share with you that you send out to companies. We can talk to you a little bit, give you some suggestions on what companies may be a good fit for you based upon your geographic location and the problems that you've had with your current management company. We can help you with the hiring process, the RFP, sending out the RFP and helping you with the hiring process. We also have a cheat sheet on, selecting a management company, the process to do that, and questions you can ask in the interview. So we're here to help you. I mean, I guess you can do one more Hail Mary pass, right? And try to go to the president of the company and say, these are the problems we've had. And what can you do to turn this around? You certainly have the right to do that. I encourage you to do that if you think that might work. But I'm telling you, as somebody who's been around for a long time in this industry, doesn't sound like things are going to change. It's better for you to get a plan in place, get going for 2024, find a new management company. Okay, our next question, number 24. Our annual meeting is going to be held in February. It will be held outside in our greenbelt. One homeowner who has never attended annual meeting in 28 years is requesting that I videotape it and put it on our website so that he can watch it. He does not have any disabilities that I'm aware of that prohibits him from going to the meeting. Is there any law regarding this that says, since he requested it, that we have to record it? I'm not sure how we would go about doing that, and I'm a little skeptical from previous discussions with him regarding his reasons for wanting this. So no, there is no requirement that you record the annual meeting and provide it to owners. What you could do is say, okay, we're having the annual meeting. I know you can't attend for whatever reason. We'll provide you with a draft of the annual meeting minutes that haven't been approved yet within a month after the annual meeting so that, you can review what happened on the draft annual meeting minutes. If the person comes to you and proves that they have some sort of a disability, put something in writing saying, I have a disability under the Fair Housing Act. I'm asking for a reasonable accommodation. And that reasonable accommodation would be for you to videotape or audio tape the annual meeting. You may be required to do that. So you may want to reach out to your legal counsel if that happens. And if that does happen, just have somebody put their phone on and audio tape it and then give that person the audio tape of it. You're not required to hire a videographer and have a tripod and all that crazy stuff. You just have to give them the recording so they can hear it. Or another thing you could do would be to have the person be able to appear telephonically and set up a conference line or a Zoom line and just have whoever's talking at the meeting have the microphone for the Zoom right next to them. That's another possible solution here. Okay, next question, number 25, from a board member. We have always sent out unratified or draft minutes to community after the board members have reviewed prior to the next board meeting, at which time that they are approved. I know this may not be a deal, but now the president does not want minutes to be sent to the community as a draft, which means it could be 60 days between board meetings. Is sending out unratified minutes acceptable? So short answer on this is yes, as long as it's clear that it's a draft. But I do get sometimes what the president's saying, because if it's a draft of them, they haven't been approved. What if there's a mistake in them? Now you're kind of projecting inaccurate information to the community. And even though you mark it as draft, people are going to take that as this is what the minutes actually say is what's actually being done. And so it could create some problems. So maybe a workaround on that would be that the draft, that the board members review the draft And if anybody, just have the manager or board member send out the draft meeting minutes. And if anybody says, I have changes to the draft meeting minutes, then hold those draft meeting minutes for that month and don't distribute them until you can vote on them at the next board meeting. And that can be done without violating the open meeting law if the manager just sends it to one board member at a time and just says, do you have any objections to these draft meeting minutes being sent out to the membership? Yes or no. Somebody says yes, you hold it, don't send them out to the community. That's kind of a good fix for the problem you're in, the predicament you're in right now. Okay, next question, 26. So we have 37 questions, so we're almost done. Question number 26, committees. Best practices for HOAs. Should committees be handled the same as HOAs for all membership meetings open to all at any time? Okay, a cheat sheet you should look at for our firm. It's called Committee Basics. I would recommend that you take a look at that. So is it best practices to have all committees give that 48 hours notice and be open meetings? Probably not. I mean, it's a lot of work to make committee meetings open, and some committee meetings, it probably doesn't make sense to do it. You are required for an architectural committee, if you are regularly meeting as an architectural committee, you are required to make those open meetings. You have to. If you have regular architectural committee meetings, you have to make those open meetings and provide the notice, 48 hours notice, and make them open meeting laws, comply with the open meeting laws. If your committees have a quorum of the board on them and you're discussing association business, your committee has to make it an open meeting because you have a quorum of the board there. It's considered a board meeting, even though it's a committee meeting. Some large master plan communities, some 55 and over communities, they make all their committee meetings open because there's an interest and it's a social event, actually. And that's totally okay. And in those situations, it may be best practices to have those committee meetings open. But in a small 20-person community with a welcome committee of one person, having an open committee meeting to decide if you're going to deliver the loaf of bread to the new owner, it doesn't make sense. So you got to look at it on a case-by-case basis. Okay, next question, 27. Are there any regulations in Arizona regarding the issuing of fines for rules violations? Anything that requires specific time periods between warnings and actual fines? So yes, there's Arizona statute that pertains to fines and penalties. Go to our cheat sheet on the top 10 things you need to know about Arizona law. We have a detailed summary in there. Here's a quick skinny on it though. Under Arizona law, you can fine an owner if you're in a planned community or a condominium for violations of the CC&Rs, bylaws, or rules. You have to give notice of the violation and an opportunity to be heard, which means give the owner an opportunity to respond by email or come to a meeting before you can levy the fine. The fine has to be reasonable. Most important tips on this. Has to be a violation of the CC&Rs, bylaws, or rules, number one. Number two, the fine that you levy has to be reasonable. So it can't be outlandish. The judge can't look at this and be like, $500 for failing to trim their palm tree? Yeah, not working for me. Maybe $100 or $50 for not trimming a palm tree is considered reasonable. Then the next thing is make sure you give notice to the owner in writing, by mail, or however, you set up your notice for your community. Give them an opportunity to be heard. So an opportunity to give their side of the story. Then you levy the fine. So you got to set it up. Usually, you need at least 15 days to set it up, right? Between the notice, giving them the chance to respond, and then making the decision. It might even be 30 days. So those are the things that you need to know about the law in Arizona, and check out our cheat sheet for the deep dive. Okay, question number 28. A group of homeowners sent a letter to management with a series of demands and questions about board decisions that were made regarding budget and investments. The board acknowledged it, but does not believe they have to respond to the owner's letter, but invited them to the next board meeting to discuss it. Does the board have to respond to all of the homeowners' demands and questions? Okay, so a couple of things here. It just depends on the nature of the questions that were raised. I'm seeing demands too. So, homeowners want information about the budget and the investments. So there's trouble in your community, right? Somebody's upset about this. Do you ignore trouble and blow them off? No, because that kind of trouble escalates and spirals, and you don't want that. So I like your idea of inviting them to the board meeting, but you need to address specifically the letter and your response to the letter at the board meeting so that they feel that you've sufficiently answered their question. And then make sure the minutes reflect it too, because They might be canvassing the neighborhood, and you want anybody who's reading the minutes in the future to know these questions were raised and this is how we've responded. And we have responded in a businesslike and reasonable manner. So I guess, does the board have to respond to all homeowners' demands and questions? I mean, I'm going back to my time. I've been on my board now. I think this is my 15th year, not all at once, but 2 separate times. There were times when I was president where if you have this group of gadflies that they just are never happy and they're just always picking, I totally get it. It gets annoying after a while, but you still have to respond. At a minimum, respond in a way that if a judge is looking at this in the future or a homeowner who isn't familiar with the dynamics going on, they're going to look at it and be like, the board was professional and the board was reasonable in how they responded. So do we have to respond to every demand and every question? Not necessarily, but you want to do enough that you're being transparent, that you're being reasonable, that you're living up to your fiduciary duties to the corporation, and that you're being nice. And it's a fine line and it's a case-by-case thing and you got to balance things. I get that. So do your best to respond to people because honestly, even though we're not paid being board members, we signed up for it. We signed up for, I hate to say it this way, but the abuse. And we signed up for people second guessing our decisions. And we signed up for people not always agreeing with the direction that the board's taking. And you have to have a little bit of a thick skin or you're not going to survive. So be nice, be professional, but recognize that some of this is part of the job. Now, if it's teetering on harassment, which I did have on my board, and I had a few homeowners too, I just told them, listen, this is getting to the point where you are harassing me. I had a homeowner who sent me 300 emails in a 6-month period when I was the president. Now that is just ridiculous, right? And so I had to draw the line with that person and say, no more emails. Come to the meetings. I don't accept emails anymore from you. Okay. Sometimes you do have to flex your muscle and let them know that that is not acceptable behavior. So it's a fine line. You got to manage it. And so that you still are being reasonable and, living up to your fiduciary responsibilities to the corporation. Okay. Next question from a board member. Does the HOA or does the 48-hour notice need to be posted and sent to the owners when forming a committee? Okay, so your board's having a meeting to form a committee. You can provide the meeting notice. I'm not sure. I'm a little confused about this question. So I think maybe what you're asking is, do committees have to comply with the open meeting law and give 48 hours notice? And I just answered that a few questions ago, that the architectural committee, if you have regularly scheduled meetings, yes, you have to comply with the 48 hours notice. If I'm reading that wrong, and it's actually, if the board's forming a committee, do they have to give 48 hours notice, form the committee? Yes, of course. The board, anytime a quorum of the board is meeting to discuss association business, they have to comply with the open meeting law and give 48 hours notice to the members. That notice can be done in a number of different ways. You can post it at the property, or you can send an email out, or you can put it on your website. So there's lots of different ways you can do it. There's no hard and fast rule. You just have to tell your owners, this is where you go for information. This is where we're going to be posting the notices. Okay, question number 30. How should someone approach the board to discuss what the board has not followed in the governing documents? For example, the bylaws dictate the makeup of a certain committee, and the board chooses to ignore the bylaws. Should this discussion be in open meetings or executive sessions? The bylaws are clear and the actions of the board violate the governing documents are documented in the meeting minutes. Okay, so here's what I would recommend you do. So be nice, okay? If you're a homeowner and you think that the board is doing something wrong, be nice. You may not have all the facts. Maybe the bylaws were amended and that's not a requirement anymore. So be nice. You could maybe send an email, a letter, come to a board meeting and say, hey, I noticed our bylaws say this. And I noticed that we're doing this, which appears to be in violation of the bylaws. What is the board's position on this? And see what they say. If they are blowing it off and violating the bylaws, then you have certain remedies, right? You can run for the board yourself and fix it. You can go to the ADRE, file a complaint with the Arizona Department of Real Estate, have an administrative law hearing. to discuss the violation. You can file a lawsuit. You can get an attorney to write a letter. There's lots of different things that you can do to get them to comply with it. Ask them to amend the provision, to take it out if it's something that they're not doing. Okay, next question. Since we have 3 board positions open for our upcoming annual meeting and we are not anticipating any new interest, can an owner be appointed to the board if we can't get enough owners to run for the board? Okay, I think maybe this might be a question that we got a double on. So I already answered that. So I'm going to skip to the next one. Okay, question number 32. We have a board of directors recall in process. We have obtained the 10% needed to initiate the recall vote and are rapidly approaching the 20% needed to make quorum to ensure that the vote is successful. My question is, upon providing the association with the required signatures, should we or are we obligated to provide a copy or the original signatures? I would keep a copy for yourself as the homeowners that are submitting the petition and give the original to the owners, to the association, just so that they know that the signature is the actual original and it wasn't like copied and superimposed on it. I would recommend that you do that. Next question, number 33. And if you're a board that's listening to this, I'm not going to say which association this is, and you're hearing that there's a recall petition being circulated in your community, should you be sitting there doing nothing? No. Recalls are very expensive for communities. They can range anywhere from $5,000 in legal fees. I've seen them go up to 50, 60, 70, 80,000 in legal fees. So you think that there is a recall petition being circulated in your community, you need to get in front of it now. You need to schedule a town hall meeting and start talking to your owners to find out what they're so upset about. Okay, next question, number 33. In 2020, the Arizona legislature proposed House Bill 2651 regarding associations obtaining information on renters and rental properties. We cannot find anything to indicate whether this bill was ever voted out of committee and passed into law. Was House Bill 2651 ever passed into law regarding the changes of fines for not supplying the rental information? And if so, how do we go about collecting the fine? Okay, so 2020 was a weird legislative year because of COVID. So there were no bills in 2020 that passed pertaining to HOAs and condos. So that was a very quiet legislative year. So I don't have 2651 right in front of me, but if it was in 2020, I'm telling you, nothing passed. There are some laws that have passed since 2015, 14, 15, 16, all the way up to 2023 that pertain to rental properties. And so what I want you to do is go to our cheat sheet on rental properties. It's on our website at mulcahylawfirm.com. We outline in that cheat sheet everything you need to know about rental properties in a community association. And there is something that talks about if an owner doesn't provide their rental information, and the specific rental information is like the name of the renter, vehicle description, the length of the lease, if you're 55 and over, community proof that the resident is, one of the residents is 55. If they don't provide it, there is a charge, a penalty that you can charge for them, not providing it. And there is a charge that you can make them pay for just having a rental property. So check out our cheat sheet on this. It's de minimis, the charges. So don't think that you're going to be, funding the refurbishment of the jacuzzi with it, because these are very small fees. But nonetheless, I think it's like $25 for each rental and then $15 late fee if they don't provide the information. It's de minimis, but it is something. So I encourage you to check out our cheat sheet on rental properties. Just go to our cheat sheet section on our website at mulcahylawfirm.com. Question 33. Let's see, question 34. We're getting down to the end here. Oh, we got a few more questions that came in. Okay, 34. Special meetings and the timing of votes by members. If a meeting is on one subject involving a vote of the members. So you're having a special meeting of your membership, the entire membership, and it's one subject for this meeting. What is the typical protocol for when votes are due? Special meetings were always to be held for members to be able to discuss the issue, and therefore votes did not have to be restricted to be placed in advance. Times have changed and meetings are now by Zoom. There's nothing in our governing bylaws about requiring all votes in advance of the meeting and making them irrevocable as well. Problem, there's no chance to discuss and deliberate on our votes. Therefore, why even have a meeting? I feel it is not proper to require votes in advance only, and that votes should be able to be placed up until the meeting ends, or what? Okay, this is actually a really good question because it's document specific. Okay, if I were looking at this, if you were hiring me to look at this, what I would say is I want to see the CC&Rs for your association and see what we're voting on. Is it election of directors? Is it a special assessment? Is it, removal of directors, whatever. And I want to just point something out to you. So it's going to be document specific, the procedure, right? So I can't give you the answer on that because I don't have your documents. But I want to point something out to you about Arizona law. So there's a law that talks about absentee ballots and the use of absentee ballots for a meeting of the membership. So if this vote requires a meeting of the membership and you're using an absentee ballot, which proxy voting is a thing of the past, right? Unless you're under developer control, no more proxies in Arizona. You're using an absentee ballot. The way the law reads is that owners should be allowed to vote by absentee ballot, meaning they can't come. So they're going to return the absentee ballot, or in person at the meeting. It specifically says or in person. So it's possible that whatever you're voting on, that the board does have to allow them, anybody who wants to vote in person. That's an important thing for you to know, that law says that. Go to our cheat sheet. It's on there, our top 10 cheat sheet. I think it's 2 or 3, maybe on our cheat sheet, 3 or 4 on absentee ballots, and it'll give you the link to the law on this. Now, from a practical standpoint, I've been going to meetings for 27 years. I don't even want to know how many annual meetings and special meetings in the membership I've been to in that 27-year period. It's a lot. The reality is that 75, 80, 85% of the people that are voting on an issue for a special meeting are voting by absentee ballot. They're not voting at the meeting because they don't want the hassle. I mean, it's hard enough to just get people to vote, right? And so we're lucky that they're even returning the absentee ballot so we can get a vote on the issue. The reality is that voting in person at meetings, it's a thing of the past, okay? Even if you get 10% of the people voting in person at the meeting, usually they vote before the meeting even starts. They hand the ballot right when they get there. Occasionally we'll get people who listen and then they hand in the ballot at the time that we call for the ballots at the special meeting of the membership. So it's times have changed. I mean, I've been doing this 27 years. I know, I'm living it, right? I used to go to meetings back in the late 1990s and everybody came. It was stressful for the lawyers who attended the meetings because we got all these ballots at the meeting. I remember I used to have to psych myself up for going to this one association for their annual meeting because we had to count 5,000 ballots. And we had to be really efficient because people were waiting at the meeting for the results. So we used to bring in a whole team of people. I mean, it was crazy. Times have changed. Now, most of these votes are absentee ballot. The ballots are tabulated in an Excel spreadsheet before the meeting, the day before the meeting. And maybe we get a handful of ballots in person at the meeting. So times have changed. You got to change with it. What I would recommend is do the education on the issue that you're voting on the front end. Have a town hall meeting before the ballots are sent out. Have detailed description of the pros and cons of whatever you're voting on in a publication with the ballot so people can read it if they're interested. I hope that helps answer your question. Maybe your association does have to start accepting ballots at the meeting because of the requirement under the Condo Act and the Planned Communities Act that I talked about earlier. But the reality is, even if you force that, people are already going to be voting and deciding on this way in advance of the meeting, just FYI. So what you really should be asking for is discussion on this before the ballots are sent or at the time the ballots are sent. Okay, question 35. We have 39 questions, so we have 5 more to go. When or how often should an HOA review its documents? Should this be a committee or board only? So I'm assuming you're asking this question, review your documents maybe for possible amendments. I think a good rule of thumb, a reasonable rule of thumb, would be that you should do a document amendment about every decade for your association. That's number one. Number two, if you're talking about just reviewing the contents to understand what they say, every board member every year should do a quick spin through the documents. By quick spin, I mean get the 3 documents that you really need to know 4 maybe. So CC&Rs, bylaws, articles of incorporation, rules, maybe architectural guidelines. Put them in front of you, page through them for 15 minutes total. That's it. Just so you understand the lay of the law and that you lay of the land and you know what each document kind of has in it. That's a recommendation that I would give to be an A+ board member. Okay, question number 36. If an HOA is given a question about finances and the board requests that the homeowner sit down and review with the board and the homeowner refuses, what should transpire with this action? Actually, this just kind of makes me laugh because, okay, we've got an owner that's asking a question about finances, right? They want answers because they're asking questions. Then you offer to meet with them to answer it and they don't want to meet. There's some dysfunction there. Like either they want attention or they want to cause problems or they know they're wrong and they don't want the answer. They just want to keep spinning the misinformation. So I think as a board, you need to look at this like maybe what you should do just to protect yourself is during an open board meeting, say, hey, we got these questions from whoever. You can use their name. You don't have to use their name if you don't want to. Raising these issues. And we wanted to spend a few minutes at the meeting talking about it. Okay, so we got the letter, whatever. We asked to meet with this person. The person wasn't able to meet with us or didn't want to meet with us. And so we're giving our answers now. Be brief, answer quickly, move on. If this person is spitting misinformation in the community and it's turning into a problem, then maybe have a town hall meeting or maybe have a general communication to your membership about what's going on with the financials that kind of addresses this issue without pinpointing that this owner is out there spreading misinformation. I say this every year, and I'm going to say it again in 2024. The associations that communicate the best with their owners have the fewest problems. So if somebody's out there sending a false message, get the right message out there so that people know that the board's got things under control and that whatever misinformation is being sent out there, you're available to answer questions on it, come to a board meeting, but here's the skinny on it. Here's what's really happening. People get that. And then when the person shows up on their doorstep with the misinformation, they're not going to listen and they're not going to sign the petition to remove the board. Okay, next question, number 37. We have a longtime employee who is not doing his job on a regular basis. We want to keep him, but this has been a long-time problem. How should we handle him? Okay, I'm an employer myself, right? If you have a long-term employer who's not doing their job, employee who's not doing their job on a regular basis, what does that mean? Is that acting in the best fiduciary interest of the association? Are you protecting the corporation? You're employing somebody who's not doing their job, and they've been not doing their job for a long time. I think probably what the question is you want to keep them. Maybe you like the person, or maybe you are scared that the person's going to sue you, or whatever the issue is that's making you want to keep them on. I mean, you're running a business. This is a business, and you have to make tough decisions when you run and own a business. So what I would recommend is that you put the employee on a performance improvement plan, outline the problems, tell the person they have 30 days to clean it up or they're going to be fired. And if they don't clean it up and do what they're supposed to be doing, then you need to fire them. If you want your association to function well and you want to be respected by your community, you have to have things operating efficiently, and you can't have people on your payroll who aren't doing their job. Okay, next question, number 37. And if you need help from an attorney about what's the best way to handle the termination and the separation of that employee, you can either reach out to our firm or we can refer you to an employment law firm if it's a complicated issue to help you manage that process. Okay, question 38, from one of my most favorite clients. If a majority of the board members participate in an HOA tour, is it necessary to do a 48-hour notice when decision-making will not be made during the tour? So I'm sorry to tell you, yes. If the board is meeting to discuss association business, it is a board meeting. Even if you're just walking around doing it, not making decisions, you have to notice it. Last question for today, 39. Does an architectural committee have to notice a workshop meeting? We are working on the guidelines. Our monthly meeting is always noticed, but do these workshop meetings need to be noticed? Okay, keyword, glad you put this in the question. We have a monthly meeting. Because you have regularly scheduled architectural committee meetings, you anytime your committee meets, you have to notice it. So your workshop, even though you're not making decisions, does need to have the 48 hours notice and comply with the open meeting law. Okay, we had a great first Friday for 2024. Thank you so much for being here today for our first Friday virtual event for January 2024. We had a lot of people here today, over 90 attendees here today on Zoom and many more on Facebook Live. What I'd like to conclude today, just remind you that we offer our 15-minute complimentary review of an association's CC&Rs and bylaws for amendment procedures. So if you're an association that hasn't amended your documents in the past decade, now is the time. 2024 is your year. Send me your documents and let me know that you want to take advantage of our free review. We'll take a look at it, provide the information to you at no charge, and hopefully that will get you on the right path to achieve one of your goals for 2024, which might be to update your documents. Don't forget, we have our HOA Condo Academy class, our first one, our Neighborhood Services HOA and Condominium Academy class on Tuesday, January 16th, 2024 from 11 to 12. Hope you'll be able to join us for that. We're going to be talking about a number of different topics for that class. Check out our website to see what the specific topic is. I think we're going to be talking about hot topics and what to expect in 2024. And so I hope that you will join us for that class. We're also going to be covering rentals and disclosure and transfer fees and a number of other different things too. So please be sure to join us for that class. We also have one in-person teaching class. The virtual classes, the neighborhood services are always virtual. In January, we are also teaching 2 in-person classes, actually, same day. I'm going to be doing double duty that day. So on January 17th, from 1 to 3 p.m., I'm going to be in Scottsdale teaching at the Scottsdale Neighborhood College in person on tips for successful and legal annual meetings and how to run board meetings in an HOA and condo. And then I'm going to have a quick turnaround, hour drive out to Chandler. And I'm going to be helping teach a portion of the mayor's HOA roundtable on HOAs and condominiums, also on January 17th from 4 o'clock to 5:30 p.m. I believe the Chandler event is limited to Chandler HOAs, board members, homeowners, and managers that live in Chandler only. So you may need to contact the city of Chandler for more information on that. But I'm going to be teaching a portion of that in addition to having other speakers from the city of Chandler at that event. So hope you can join us at one of our free events in 2024, specifically in January. Don't forget our next live virtual First Friday event will be Friday, February 2nd. So put that on your calendar now. And last but not least, please consider leaving our firm a Google review. It's really important to our firm that we receive feedback from you on how you do these classes. If you've worked with our firm as a client, if you can share your experience with our firm on Google, we would really appreciate it. There's a link that we're going to be sharing with you on how to do that. That's one way that you can help me because I offer these classes. They take a lot of time to prepare for. One thing that you can do to help me, one thing that I ask is that you leave a Google review to let us know how we're doing and to let us know if you enjoy working with our firm. That helps us in our industry and it helps our firm. So I would appreciate it if you would consider doing that. We hope to see you later this month for our classes. I hope every one of you have a happy, productive, safe, and healthy 2024. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.